26.
26. I'm sorry, I was trying to look at the screen as well as enable the YouTube as well as call the case. This is cause number 10,826. The case is styled the State of Texas versus Jane Gutierrez Gonzalez. This hearing is being conducted by remote video teleconferencing technology using the Zoom protocol. This case is also being live streamed on the court's YouTube channel. Both of those announcements are to let the record know and reflect that this hearing is being conducted in accordance with orders from the Texas Supreme Court, as well as rules and directives issued out of the Office of Court Administration. This the manner of presentation also causes the court to expressly prohibit anyone from recording any portion of this proceeding by any means whatsoever. Electronic recording, photographic recording, or any other type of effort to record this using either the Zoom or the YouTube protocols. There is an exception for the official court reporter who is recording this proceeding just like he would do if we were in person in court, which we are not. We're on Zoom. With those pronouncements being made, the court understands that the defendant desires to enter a plea of guilty to the charges in the indictment and to do so pursuant to a plea agreement between defense and state. With those understandings, what says the state?
State's ready, Your Honor.
And the defense?
We are ready, Your Honor.
Are you Jane Gutierrez Gonzalez?
Yes.
Ms. Gonzalez, when speaking, you may remove your face covering.
Yes.
All right. Ms. Gonzalez, you have the right to have someone read the indictment out loud to you. Do you wish to have someone read the indictment out loud to you? I saw you shake your head as if.
No.
Okay. Do you understand that the indictment charges you with a state jail felony offense of possession of methamphetamine?
Yes.
Do you also understand that the indictment alleges 2 prior state jail felony convictions as punishment enhancement paragraphs?
Yes.
Then let me ask you, to the allegations in the indictment charging you with possession of a controlled substance, namely methamphetamine, in an amount that would make that a state jail felony, to that charge, how do you wish to plead, guilty or not guilty?
Guilty.
And to each of the enhancement paragraphs alleging prior convictions for state jail felony offenses, both of them allegedly arising out of Nolan County, Texas, to those 2 enhancement paragraphs, how do you plead, true or not true?
True.
Do you understand that you do not have to enter a plea of guilty and you do not have to enter a plea of true? Instead, you have the right to enter pleas of not guilty and not true. And further, you have the right to not have it held against you or used against you just because you might have exercised your right. Do you understand that?
Yes.
I have been handed a document entitled Waiver of Defendant, which purports to have your signature and the signature of your attorney, as well as the signature of the state's attorney. The Waiver of Defendant document says that even though you have the right to have a minimum of 10 days notice of the charge, and in fact, you have had more than 10 days notice of the charges. Nevertheless, I could and would grant to you some additional time to prepare before we went to trial in your case. And we have a jury trial, a jury impaneled, I'm sorry, not yet impaneled, but scheduled to be impaneled next week. So we would have a jury available to try your case, and we would grant to you that additional time if you wish to have it. And you also have, says this document, that you are aware that you have the right to a jury trial. And the right to a jury trial exists even if you enter a plea of guilty. In other words, you could enter a plea of guilty to the jury as well. Do you understand that you have those rights and those opportunities?
Yes.
Now, the waiver of defendant document goes further, though, and says you are giving up the right to have additional time to prepare, and you're giving up the right to a jury trial, which means your case will be heard by me today without a jury. Did you understand that's what this waiver of defendant document was saying when you signed it?
Yes.
Mrs. Fuller, as I say, your signature is on this document as well. Let me ask you, Mrs. Fuller, did your client sign the waiver of defendant document in your presence?
Yes, she did, Your Honor.
And then is this your signature evidencing that you're joining your client in these waivers?
Yes, I am, Your Honor.
Mr. Smith, your signature also is on this document. Is that evidencing that the state is joining in the waiver of the right to a jury trial?
Yes, Your Honor.
All right, I will accept these waivers and we will proceed with this guilty plea hearing. Ms. Gonzalez, there are other rights and admonitions I need to discuss with you. And so let me start out by talking about and telling you about the range of penalties that exist for this type of case. A state jail felony, like is the underlying allegation in your indictment, carries a range of penalties running from 180 days up to 2 years in state jail, and also carries the possibility that a fine could be imposed, if imposed, to be in an amount not to exceed $10,000. But we've also discussed the fact that there are 2 enhancement paragraphs alleging prior state jail felonies. If you are convicted of the underlying offense of possession of a controlled substance, and if those allegations of prior convictions are proven, the enhancement of the punishment range makes the punishment range you would face under this indictment that of a 3rd-degree felony, which carries a range of penalties running from not less than 2 years to not more than 10 years in the Texas Department of Criminal Justice. The punishment range also carries the possibility that a fine could be imposed, and if imposed, to be in an amount not to exceed $10,000. Do you understand? Those are the ranges of punishment you face under this indictment.
Yes.
Now, I am also aware that a plea agreement exists in your case. I have looked at your plea agreement. But I tell you, I do not have to follow your plea agreement. I have to tell you if I'm going to follow it or not, because if I decide not to follow your plea agreement, then the law would grant to you another right, namely the right to withdraw your plea of guilty. Or restated, hopefully more simply, if I don't follow your plea agreement, you can take back your plea of guilty. And if that occurs, we just start all over, and nothing you have signed for today's hearing and nothing you have said so far will be used against you. So now let's talk about what happens if I do accept your plea agreement. If I do follow and accept your plea agreement, then the law says you will be bound by the terms of that plea agreement, and you will not be able to get out of the terms of the plea agreement just because you don't like them anymore, or because you later change your mind, or you wouldn't even be able to get out of the plea agreement terms by appealing your case. And I say that even though ordinarily there is a right to appeal in Texas, even from a plea bargain agreement, unless one of the terms of the plea agreement says you give up the right to appeal as a part of the agreement itself. Your plea agreement has that term in the plea agreement marked as one of the terms. And so it means if I follow the plea agreement, you cannot appeal at all. Do you understand that?
Yes.
And understanding that, are you still telling me, I'm sorry, understanding that it does mean what it says, that you could not appeal. Now let's go further with the discussions of the plea agreement and the plea procedure. And so let me ask you some questions about some matters that I'm required to ask by state statute and court decisions. The first one of those questions is, are you a citizen of the United States of America?
Yes.
Where were you born?
In Coleman, Texas.
My next question asks you, do you consider yourself presently to be mentally competent?
Yes.
Do you know what's going on in these proceedings this morning?
Yes.
Have you been able to understand the charges so that you could discuss and cooperate with your lawyer in discussing the facts of your case, as well as to hear her advice about the law, and thus, in cooperation with your lawyer, plan for how you would respond? Have you had those opportunities?
Yes.
Mrs. Fuller, do you believe your client is mentally competent?
I do, Your Honor.
All right, I accept that representation based upon my conversations and observations of Ms. Gonzalez this morning, as well as in prior hearings we've had in this court. Ms. Gonzalez, my next question asks, are you satisfied with the legal representation you have received in these matters?
Yes.
And let me tell you why I asked that question, because I'm not trying to suggest that you wouldn't be or shouldn't be satisfied. Instead, I asked that question just so you would have a chance to tell me if you were not satisfied, if you thought your attorney's work was somehow deficient. My question would give you the chance to tell me, and we would then work, I would then work to try to alleviate or remove any problems that representation caused. But I would also tell you that since I've given you and are giving you the chance to let me know now if there's any problems with the attorney's representation, that effectively means you cannot wait to some later date to say your lawyer didn't do a good job. To do so would in all likelihood be unsuccessful, because now is the time to tell me if that were to be your thought. Do you understand that?
Yes.
And understanding that, are you telling me that, are you still telling me that you're satisfied with your attorney's representation in these matters?
Yes.
Then let's go into another matter, this one dealing with your decision to enter the plea of guilty. The law says I must be satisfied that you have freely and voluntarily entered into the decision to plead guilty. And so to make sure about that, I ask you these questions. Has anybody threatened you or forced you or tricked you or in any way tried to make you enter a plea of guilty when you would not otherwise do so?
No.
Has anyone promised that you would get something of value, just be it money or anything else, just to get you to plead guilty when you would not otherwise do so?
No.
Are you telling me then that you're pleading guilty to this charge and true to the enhancement paragraphs because in all truth, you are guilty of this charge and those enhancement paragraphs are true? Is that what you're telling me?
Yes.
Then those are all the questions I have at this time, Mr. Smith, you may proceed.
Your Honor, the state offers for evidence a document marked as State's Exhibit 1. State's Exhibit 1 being this defendant's signed and sworn stipulation of evidence in this case.
We have no objection to the admission, Your Honor.
Ms. Gonzalez, then let me talk to you about this stipulation of evidence because it also has the signature that is the same as the others on the documents before me. And it says that you swore to the statements contained in the stipulation before a notary public. And so I also tell you of another right that exists and it fits right here in order for me to tell you about that in the stipulation. Under Texas law, I tell you that the state is required to produce some evidence tending to show your guilt. And that's true even though you plead guilty. You have the right to require the state to bring those witnesses into court who would testify about your case and require them to be sworn in and testify in front of you so that you could see them and hear them while they're giving their testimony, thus enabling you to assist your attorney in cross-examining and questioning or challenging those witnesses' testimony. But this stipulation of evidence says instead you're giving up that right, and instead you're telling the state they don't have to bring their witnesses into court at all, thus giving up the right to confront the witnesses. Did you realize you were giving up that right when you signed the stipulation?
Yes.
The stipulation also says you're giving up your right to be free from, or you're giving up your right to remain silent and to be free from self-incrimination. That last right is the right to not be forced to give evidence against yourself. But instead, you are giving evidence against yourself because this stipulation of evidence is a judicial confession wherein you admit that all of the material allegations set out in the indictment are true, that you committed the offense as alleged, and that the enhancement paragraphs alleged are true. Did you realize you were doing those things when you signed the stipulation of evidence?
Yes.
The stipulation also says that there are court costs in the sum of $290. There will be a restitution obligation of $180 and a reimbursement owed to this county in the amount of $675 for reimbursement fees. Did you realize that was in the stipulation of evidence as well?
Yes.
Then State's Exhibit 1, the signed sworn stipulation of evidence, is received as evidence in this cause.
State rest, Your Honor.
And close.
Okay.
State closes.
Then Ms. Gonzalez, I announced in cause number 10,826, style, the state of Texas versus Jane Gutierrez Gonzalez, that based upon your plea of guilty, based upon the evidence stipulated to, as well as your plea of true, that you are guilty of the offense of possession of a controlled substance as alleged in the indictment, and that both enhancement paragraphs set out in the indictment are true. Having made that pronouncement, do you know what, let me discuss your plea agreement with you before making that pronouncement, because that would affect how we proceed. As I understand the plea agreement, it says you will enter a plea of guilty as you have done. It says that's going to result in a 5-year sentence to the penitentiary with a fine being imposed in the amount of $1,500. That court costs will be imposed in the sum of $290 and a reimbursement fee or reimbursement fees in the sum of $675 will also be assessed. Finally, that from a financial standpoint, that there is a restitution obligation totaling 180 days. The plea agreement says you will waive or give up your right to appeal, as we have already discussed. It also says that you will be given back time credits totaling 2 days. Now, that's my understanding of the basic plea bargain agreement in your case. Is that the same as your understanding of the plea bargain agreement?
Yes,
And are you asking me to approve the plea agreement that I've announced?
yes,
All right. I announce that I will follow and approve your plea agreement. And so, with the pronouncements made that the court finds you guilty and finds based upon your plea of guilty and the stipulations of evidence, and that the enhancement paragraphs are true, do you know of any legal reason why a sentence should not be imposed at this time?
no,
Then I hereby sentence you to serve 5 years confinement in the Texas Department of Criminal Justice as set out in your plea bargain agreement. I order you to pay a fine of $1,500. I assess court costs in the sum of $290. Order reimbursement fees to be paid in the sum of $675. In order you to pay restitution in the sum of $180. I also follow the plea agreement and grant to you 2 days time credit for time served so far. Do you have any questions about any part of this proceeding this morning?
no,
Then those will be the orders of the court. Your thumbprint will be required on this judgment. You will be remanded into the custody of the sheriff's department, and the sheriff's deputy will appear at your door in the conference room where you are seated, and we will be in recess. Ben, let me ask you a question, if I may.
Yes, sir.
Are we still doing, are we going to do, what's his name, Richardson this morning?
That's my understanding, 11:30. I know Trey has the plea papers. Actually, I think, let me ask Jared real quick. Hey, Jared?
I just sent them to Joe.
Okay, so Trey has reviewed them and signed them, and we've sent them to the jail. Okay. Did you hear that, Judge?
Most of it, so I think I understand.
Yeah, plea papers are now at the jail. Trey's reviewed them and signed them. And so, yes, sir, we're supposed to do Richardson this morning.
If he in fact goes through with that plea, does that dispose of our trial docket?
Yes, sir, I believe it does. I know from a technical standpoint, Holman is still out there, but that's a plea case, Judge. I really have high confidence that's a plea case, and I understand the guy probably is socked in Austin.
Yeah.
Based on some of our relatives that happen to be in Austin as well. I know conditions are pretty bad there.
Well, I've been talking with my daughter in Dallas and my neighbor at our condo this morning, and we've got some fairly major problems at the condo, and hopefully my daughter is not having major problems. But she was worried about it. So that's north of Austin, and Austin is often a little bit better, but my understanding is it's extended well south of Austin.
Yeah.
So what I told Kayla a little bit earlier this morning is nobody would, no court would uphold my efforts to sanction anybody because they couldn't make appearances due to the weather that we've had this week. So why try to get into a position to impose such sanctions? So that's going to apply to Plunkett as well. The bondsman, Connie, was going to drive over and get her. But she was having her own problems. Connie. So she wasn't sure she could get there.
Where's she supposed to be? Plunkett.
Abilene.
Oh.
And we could do it by Zoom, assuming that she could dial in, connect in. But as we've discussed before, I think we need to have some connection to Scurry County
I agree.
on a periodic basis. And so I'm going to reschedule Plunkett and Holman for Monday morning.
Okay.
I haven't talked to Trey yet. We can do that when we talk to Trey regarding Holman. And I'll hold off announcing anything about the jury until we know at least that Richardson takes care of his business. I may tell Trey that I'm holding off announcing, dismissing the jury until Monday morning in case Holman doesn't show up, but I'm confident he will too. Is Holman a probation plea offer?
It is, Judge.
Is it a possession case?
Yes, sir. It's a mushroom case.
Oh, okay.
Yeah.
Okay. Well, I'll see you a little bit later this morning when Trey and, well, his client is available. I'm hoping Trey is staying at home and not getting out on the roads this morning.
Since he emailed things, which is rare for him on these pleas, I expect he's staying home.
Okay.
All right.
All righty. See you later.